Welcome back to the HeirKare Podcast with Kathleen and Erik. How are you doing today, Erik?
I'm doing pretty good today. How are you doing?
I'm doing great. You ready to talk about the healthcare power of attorney today?
Yeah, let's go ahead and jump into it.
All right. So last time we were with you guys, we talked about the Advanced Directive for healthcare. Today we're talking about a related document, the healthcare power of attorney, but it is a more broad document that covers situations where it may not be end of life, but you still need someone to help you make decisions. So we're going to take a minute and look at the form, and I'm going to pull that up real fast, or I should say, look at a sample. And just like last time, our hypothetical clients are the Washingtons, right? So we've got George Washington here. And this first page, and this is the Tennessee form, you'll see a similar disclaimer page essentially on the front of many different state forms. And this page is basically to say, hey, guess what, people? You're giving a lot of power to someone to make decisions for you, including life and death decisions. And then it talks about how you can amend it verbally or in writing in Tennessee, gives some other information about what the nature of the powers in this document are. So this is just kind of like a reminder and a warning about what you're signing, because it is a very powerful document. The next page, you'll see where this is a little more substantive. Hey, this is for George Washington, and this is where he lives. Who does he want to make decisions for him if he can't? He's here selected his wife, Martha Washington. Well, what if something happens to Martha? Martha's not available. In that case, we've got a backup named. In this example, we've got his grandson, George Washington Parke Custis. What you'll see also as you scroll down through this form and many other state forms, I would venture to say all of them, but at least all the ones that I'm familiar with, they always have some language to give HIPAA authorization to your agents, because it's not very helpful to have a written authorization to make decisions if you aren't actually allowed to receive that financial information, or if the agent isn't allowed to receive the financial information. So you'll see some language giving that HIPAA authorization, which I'm sure you guys are familiar with, because every time you go to the doctor's office, it seems like they want you to fill out a HIPAA form. Most powers of attorney will then have a very broad general reference to the powers that are granted without specifying any categories. Sometimes you may also see references to state law in this more introductory paragraph. And then it's really typical to see some headings that specifically authorize certain powers. It is not necessarily limited to the powers that are listed here, but it is a way of giving people guidelines and information and, hey, definitely yes, these powers. And so some of them are pretty basic, right? Give access to medical records and other personal information, to hire and fire medical personnel. So that could be a dentist, that could be a nurse, that could be in-home care, that could be the doctor. I think this is a big one here. Give, withhold, withdraw, or modify consent to medical treatment. So if you have been receiving some treatment for maybe a condition that's not terminal, but it has messed up your mind, right? We see that sometimes with happens with certain infections, and also the actual treatment can sometimes cause you to lose your capacity to make decisions. And so this would give your agent the power to modify that for your benefit. Exercise and protect your rights. So as we all know, our health information is supposed to be protected, and your agent here is allowed to take the actions you could take to protect those rights and advocate for you in that way. Most healthcare powers of attorney, you will see a lot of language specifically around pain relief. A lot of that has to do with the fact that lots of pain relievers are addictive and opioid derivatives. And so those obviously can have very severe adverse side effects, including addiction, can shorten your life, can suppress breathing, things like that. So you'll see extra language usually around pain relief in these healthcare powers of attorney. Also to grant releases. Erik, I don't know if you want to jump in and say anything about releases. I've been talking for a minute here.
Yeah, so I mean, it's really kind of the ability in certain situations, you've got to be able to sign something that maybe is different from what the doctor's saying, or say, like, hey, I don't think that they want to do that. And then the doctor's office may say, well, we're not going to be responsible for you not following our advice. You need to sign this form that's releasing us from that liability, right? So, like leaving as medical advice, those types of situations. your agent needs the ability to sign that form, otherwise the hospital is not going to release you because you haven't signed the form, right? And so it's kind of just creating that power so that they've got the flexibility to deal with the situation as it comes up.
Yeah, thanks. You'll see a couple other things in here provide for your residents. So let's say you become wheelchair bound, your healthcare power of attorney has the right to get a ramp installed, get a zero entry shower installed for you, things like that to make your house safer for you to be in. Provide for companionship. Oftentimes, when people are older and maybe they're more homebound, they can't drive as much, they just need someone to come in and hang out with them, take them out to eat every now and then, and just to be with them. And so that's allowed under the healthcare power of attorney. Make funeral arrangements. So we always recommend that individuals make their own funeral arrangements if at all possible, but we understand a lot of people don't do that. And so this document gives your agent the power to make those arrangements in the event you have not. And then if you choose to include this, it also can grant the power to make anatomical gifts. I think we all understand what that is. It's organ donation, things of that nature. They can sign documents on your behalf, excuse me. Um, so this can have to do with liability issues. So if there was a medical malpractice suit or something like that, um, you have the power as a healthcare agent to do that on behalf of the grantor in the document. Then we'll see some specific authorizations, and these are generally related to authorizations related to end of life decisions, but there are not instructions here. The way we have got our documents structured, unless people request otherwise, is that the healthcare power of attorney gives a broad grant of authorizations, and the end of life instructions are in the advanced directive for healthcare. So there's a little bit of overlap here, but that advanced directive is going to be a little more specific. And then, hey, if your healthcare power of attorney buys you some Tylenol, they can get reimbursed. If for some reason the healthcare power of attorney is not getting the job done and you need a conservator or a guardian, depending where you are, it says, hey, whoever I've selected here is to be my conservator or guardian, at least as it relates to my person and those types of decisions. And then you'll see some, boilerplate things about governing law and how these powers can be modified by the signer of the document. And then you'll have the signature page. In Tennessee, we tend to just notarize things. In Virginia, you must have two witnesses. Most states are some combination of notarization and or two witnesses. And so if you are trying to wing this on your own, which I definitely don't recommend, keep those things in mind and make sure that you are finding out what the rules are in your jurisdiction. Because, for example, if you live in Virginia and you sign your healthcare power of attorney and you have it notarized, that actually is not valid. It needs to have the two witnesses, even though it's notarized. I know that's weird, but that is what the statute says. So I'm going to stop sharing my screen here. And Erik, why don't you let us know what kind of questions do you get from your clients about this document?
Yeah, so probably the first one I always get is, okay, why do I have two separate healthcare documents? Why is there a healthcare power of attorney and then I also have to do this other advanced care directive thing? And kind of, I guess, tied in with that is we'll often see people come in where they're both those things are covered under one document. And
Mhm.
so clients will kind of want to know, okay, well, my old one was under one document. Why do I have two now? So what's kind of the answer you give to that when you get asked those questions, Kathleen?
Yeah, so I say, first of all, at least in my jurisdictions, there's no rule about having to have two separate documents or one. While there are even state forms, generally speaking, you are not required to use those state forms. Some attorneys like to put the healthcare power of attorney in the same document with the advanced directive. I have seen that becoming less common because I think the clarity is between understanding which documents apply when is really helpful. And why do you need two? I would suggest the reason that we recommend that you have two is because the advanced directive gives instructions for end of life, right? And again, this is often sometimes called a living will. The healthcare power of attorney is any time that you have lost capacity, and it's anytime, right? So that could be a situation that's not end of life, which can happen several ways. And Erik, if you want to jump in here, you can maybe
That's
give some examples of that.
Yeah, the example I kind of use a lot is, your healthcare power of attorney is even going to apply in a situation where you're going in for a routine surgery and something comes up in the middle while you're under anesthesia, and somebody's got to be the person who can tell the doctors when they're coming in saying, we've got two options here, which way do we want to go? Somebody's got to be able to make that decision. They're not going to wake you back up in the middle of a surgery just to ask you, do you want to go with plan A or plan B? They're going to talk to your healthcare agent. And that is a situation that is completely outside the scope of an advanced directive. And having it in two separate documents can also make it clearer for the healthcare provider. Okay, we're not end of life. Okay, we can just set that document aside, look at the other one that's clearly for these situations. So it can just provide some clarity and streamline things a little bit, that they know this is exactly what we're doing and when we're doing it.
Yeah. And another question that I get pretty frequently, Eric, is people come and they say, "Well, I'm not sure who I should appoint. Who should I appoint? Does it have to be a family member? Are there criteria? Do they have to be medical?" How do you respond to that question?
Yeah, so I guess number one is, well, that should be my kid who's a nurse. Well, maybe, but not necessarily. You normally want to be picking somebody who's going to be emotionally able to make the same kind of decisions you would make or want made in that situation. There's I've had plenty of clients who are like, my son's a doctor. He thinks that, everything should be done this way, and I don't agree with that. Well, then, yeah, you don't want to pick that son to be
Mhm.
handling your healthcare decisions for you, right? Even though
Mhm.
he's the one person in the family who's a medical professional. That said, often it is pretty common for us to see that if there is a child or, a niece or nephew who is in the medical field, that you might want to be naming that person. I think the preference there is always tends to be with they're going to be able to communicate with the healthcare providers easier, right? They know the jargon, they know the lingo, they know what things are going to be done. They know what other questions might need to be asked in a certain situation. That someone who isn't in the medical field may not even have any clue that you could even ask for that other test to be done in addition to this the one that they're recommending. And so that there is a tendency with clients to want to pick somebody with a medical background, but they absolutely do not have to be. For me, I always tell people the most important thing is that it's somebody you trust to make decisions in line with how you make decisions.
Yeah, for sure. And I also advise people against picking an individual who has a severe anxiety or depression disorder. The issue there is, if we can at all avoid it, we don't want to put our loved ones in a position where they're being given a responsibility that for their health reasons they're not able to manage. And so, that's not very often, that's not removing anyone from the running and deciding who's going to be your agent. But, mental health is a real thing. And so I just always remind people, hey, if you've got a kid with a severe anxiety disorder who's having frequent panic attacks or is triggered by medical situations, yeah, don't pick them, even if they're the firstborn kid, right? Um, so that's just one other piece of advice that I give people. It doesn't have to be somebody that's related to you. It doesn't have to be your spouse if you're married, often it is. It doesn't have to be someone who lives in the same state with you, at least in my jurisdictions. And so, obviously there's a benefit to having somebody who's closer who can be there and advocate on your behalf more frequently. But if that person doesn't live close to you, that's okay. You can still choose them if they're the right person to be making the decisions. All right. Any other final thoughts you have on this document, Eric?
A lot of times we have people come in and they say, well, my wife's going to be making my decision, and of course it isn't, and of course my kids, and so do I even need one, right?
Mm.
And my answer, and you can chime in if you've got any other thoughts on this, but my answer is always, it's anytime you can have something in writing that you can hand over to a healthcare professional and say, here's who I want deciding these things, that just clears up a lot of things, makes it so that nobody has to worry about, okay, well, did we talk to all of the kids, right? No, we don't have to. We've named one child who's going to be making the final decision. Because I know you and I have been involved in a case even where the kids couldn't agree, and the hospital ended up having to file a conservatorship petition because they didn't know who to listen to, right? And so
Yeah.
having it in writing can give clarity for everybody, so things can be moving along and make sure that you're provided for and your care is provided for very well and in a timely manner and all those things. Yeah.
That actually brings up just one other point I wanted to make is sometimes people want to know if they can appoint two people to serve together as co-agents. In Tennessee, that's allowed. In Virginia, that is not allowed. So that's going to vary by state. I don't recommend, generally speaking, appointing two people as your primary agent because of the possibility of deadlock. I would rather have three and, say majority rule if there's not total agreement, or just one. But again, that's going to vary by your family situation and the state rules and regulations. So just keep that in mind as well when you're picking who's going to make decisions for you if you can't.
Yeah, absolutely.
All right. So I think that wraps up our review of the healthcare power of attorney. I hope this helps you guys understand the document, why it's important, why we recommend you have one. And stay tuned because we're going to keep marching through these basic important documents for the next couple weeks. Thanks.